Briefing on the application to Ismail and the Secretary of State for the Home Department.
Mr. Ismail is an Egyptian national, and in 2006 he was the chairman of Salam Maritime Transportation Company. And on the 3rd of February 2006, sadly, a ferry operated by that company sank in the Red Sea, and more than 1,000 people lost their lives as a result. Mr. Ismail was charged with manslaughter subsequent to that tragedy, and at the first hearing he was acquitted of that charge. The prosecution appealed, however, and he was convicted by the Court of Appeal, and the Court of Appeal sentenced him to a period of imprisonment. That sentence was imposed in March 2009, and almost 3 years before that, Mr. Ismail had left Egypt and come to live in the United Kingdom. And indeed, he and his son have remained living here ever since. In 2011, the Home Secretary the Egyptian authorities asked the Home Secretary to serve the judgment of the Egyptian Court of Appeal on Mr. Ismail. She informed him that she intended to do that. His lawyers objected. They claimed that she would be acting unlawfully if she served the judgment. An exchange took place between the lawyers acting for Mr. Ismail and the Home Secretary, and that failed to resolve the issues between them. And ultimately, lawyers on his behalf asked the Court of Appeal to say that the Home Secretary was not legally entitled to serve the judgment. After a hearing before the High Court, the Court agreed that she was not legally entitled to serve that judgment. The Home Secretary then appealed that decision to this Court. We have unanimously allowed the Home Secretary's appeal. Mr. Ismail's lawyers had argued that serving the judgment would have irreversible consequences for him. They said that it would trigger the start of a short period during which he would be obliged to appeal the decision if he wished to challenge it. And moreover, in order to appeal the decision, Mr. Ismail would have had to return to Egypt. And it was claimed that he would there be taken into custody, moreover, on foot of a judgment by the appeal court after proceedings which he said were manifestly unfair. And it was therefore argued that to serve the judgment on him would involve a breach of Mr. Ismail's rights under Article 6 of the European Convention on Human Rights and Fundamental Freedoms. Article 6, of course, being the provision which guarantees the right to a fair trial. The Home Secretary, however, said that service of the judgment would not have that effect. It did not enforce the judgment, nor did it ratify it. Moreover, service of the judgment did not expose him to any risk of prescribed ill treatment. We find that Mr. Ismail would undoubtedly be placed in something of a dilemma by the service of the judgment, because he had to decide whether to go back to Egypt or to remain living in the United Kingdom. But placing him in a dilemma, we felt, was something far short of saying that his convention rights had been infringed. Service of that judgment would certainly have narrowed his legal options, but it did not alter his legal status. We therefore felt that in this particular case, Article 6 was not engaged. But there may well be cases in which it would be, and we make that plain in the judgment. If service of a judgment in a case different from the present would lead more directly to its enforcement, or would have other material adverse consequences for the person on whom it is served, Article 6 might well be engaged, but that is not the position here.